Welcome back to episode 38 of the Real Estate Syndicator Live. And if you are a new syndicator or somebody who hasn't even started syndicating and just thinking about syndication, you have come to the right place. Today is going to be sort of a back to basics. We've been talking for the last 39 episodes about pretty detailed stuff, but I wanted to go back to basics. We're going to talk about why the SEC is even involved, all the exemptions. We're going to talk about joint ventures, social media, pre-existing relationships. We're going to do like literally an intro 101, and then of course I'll open it up to questions. And if you guys have more advanced questions, I'm happy to answer those as well after we give the sort of the newbies a chance to do it. So let's get going. The first question I think everybody should ask themselves, and it kind of frames the whole conversation, is, why is the SEC, the Securities and Exchange Commission, why is the SEC in my face? I'm buying a piece of property. Maybe I'm just getting together with a bunch of my buddies and I'm raising some money to go buy a duplex or triplex or whatever. Why is the SEC involved? And that's an important question because the answer is critical. The answer to that is because the definition of a security is extremely broad, right? Like most of us think of securities as stocks, bonds, mutual funds, maybe promissory notes, although some people don't think of those as securities, which they are, but they just think of sort of the basics, right? Security, stocks. And it includes a lot more than that, right? It includes, promissory notes, as we discussed before. It includes tenants in common. So if you're trying to buy something and skipping the LLC and you're just trying to have everybody a direct ownership versus via TIC or tenants in common, that's security. Profit sharing agreements are security. Side agreements, as I like to joke, high fives and handshakes are all securities, because the SEC doesn't care how you structure a particular deal, whether it's real estate or any other asset class. They care about what you're doing. And so my sort of cheat sheet definition of a security is anytime you're raising money from individuals where the returns are generated by your efforts, you're doing all the work and the investors are simply writing you a check and going home, that is a security. And how you structure it does not matter. The SEC is going to look straight through your fancy structure or the ways you think you can get around the securities laws by doing a promissory note or calling it a joint venture, which we'll talk about in a second. They don't care. All they care about is, are you raising money from investors? Are you doing all the work? Are the returns generated by your efforts or the efforts of the GP team? That is going to be a security. And so one of the questions I get all the time is like, well, what about a joint venture? Like, hey, why don't I just do it as a joint venture then? That way I kind of get around the securities laws. And of course, that's not the case. Calling something a joint venture, no, the SEC couldn't care less, right? What they're looking for again is, are you the one doing all the work, and are there passive investors, or are there not? If you structure your deal where everybody is actively participating in the generation of the returns, right? So everybody's rolling up their sleeves, then that's a true joint venture. But the minute you have even one investor in there that's passive, that just wrote a check or really isn't doing too much at all, that's going to run the risk of being a securities offering. And it happens time and time again where I get calls from clients that say, hey, I'm going to structure it as a joint venture. We actually don't do joint ventures. So I farm it out to, or not farm it, I refer it out to somebody I've been working with for a very long time. And many times the attorney will call me back. If you guys have worked with Alan before, Alan will call me back and say, hey, look, I've talked to the client. This looks like a security, because the way they're structuring it, the way that there's some investors in there that are passive, that's going to be a securities offering, whether you call it a joint venture or not. So that's kind of the key point to start off with. Like, you are in the business of selling securities because you're doing all the work to generate the returns. And so then the question becomes, now that you understand that you're in the business of selling securities, there's really only three things, big picture, that you need to think about. Number one is to register that syndication with the SEC, or number two, find an exemption to registration, or number three, it's illegal. That's it. Register, find an exemption, or it's illegal. Now, we generally don't want to register. In fact, we don't register at all, because that's basically going public. That's doing an IPO. That's going to take you 18 months, 24 months, going to cost you 7 figures. We just don't have time. We're in contract to buy a building. We got to close the sucker in 60, 90, 120 days. We don't have a year and a half or 2 years to go through the process of registering it with the SEC. So we never, I almost never say never, but on this one, I'm going to say never. We never register a full-blown registration with the SEC. We don't file anything with the SEC. We don't want to do anything illegal, obviously, or even non-compliant, right? And doing something illegal doesn't mean that you're running a Ponzi scheme or you're Bernie Madoff or you're just something doing completely nefarious. I mean, obviously that's true. If you're out there ripping your investors off and committing fraud, FTX, then yes, you're going to be in trouble. But even non-compliant things like doing things that you're not supposed to, sort of, maybe advertising on social media or advertising anywhere when you're not supposed to advertise, or maybe paying people you're not supposed to pay. Any of that stuff is sort of the illegal part of it, which obviously we don't want to do. And so we don't want to register. We don't want to do anything illegal. So we're always left with number two, which is you're looking for an exemption to registration. And that's what I do. That's what Bethany does, everybody at Premier Law Group. And that's what you're looking for, is an exemption so that you don't have to go register with the SEC. And that's where you hear these 506B, 506C, Reg A, all those kind of statutory things. Those are just the exemptions that we rely on so that we don't actually have to go ask permission for the SEC and give it to the SEC for them to review and give us the thumbs up or thumbs down. We just do it. We're obviously complying with the rules, but we just do it without really asking for permission. We just have to document everything pursuant to the particular rules. Now, there's a reason why you've probably heard a lot of 506B. Even if you're a new syndicator or you're thinking about it, you always hear 506B, 506C. Those are by far the most popular exemptions that people rely on. The reason for that is twofold. Number one is that they're safe harbors, meaning that there's 6 or 7 bullet points and rules that we have to follow. But if we follow those 6 or 7 rules, then we're assured basically that we're in compliance with that exemption. There's no guesswork. There's no, like, I'm not relying on somebody's subjective, well, to an extent, but anyway, I'm not really relying on, hey, I've hit these six things, I'm good. There's no guesswork. So that's obviously always nice to have. You don't want to be, uncertain about things. You want certainty. And so these give you certainty. These are safe harbors. The other big deal about these two exemptions is that they preempt state law. Preemption is just a fancy way of saying we don't have to worry about the states. Because remember, we live in a system that has both the federal laws and state laws. And so can you imagine if you had to comply with the complicated rules and SEC laws at the federal level, and then you still had to worry about all the states where all your investors are in? I mean, just imagine if you were doing a raise and it happens sometimes, but you're doing a raise and you've got investors from like 6 or 7 different states. You'd have to go hire an attorney in every single one of those states. You'd have to, obviously spend the time and the expense of getting those things done. And then you've got to structure your syndication so that it falls within the parameters and the rules of each one of those state securities laws, in addition to the federal. That's a nightmare. Right. And sometimes it just can't be done. I mean, these rules sometimes just kind of are not polar opposite, but it's just sometimes it's difficult or impossible to structure it to appease everyone. So the fact that these preempt state law, this means once I comply with 506B, 506C, and a couple of others, then I don't have to worry about the states other than the anti-fraud provisions. There's always, you can't, again, if you're ripping off and committing fraud or running a Ponzi scheme and you're intentionally defrauding your investors, trust me, the states are going to have their say. But generally speaking, if you commit any other sort of irregularity, as long as I'm complying with the federal laws, I don't have to worry about the states other than the anti-fraud provisions. And also we have these Form D requirements, which I'll go through in a second. But either you guys that have done this, within 15 days of our first sale, we have to file just a notice filing with the SEC. We're not asking for permission. We're not doing anything. We're literally just saying, hey, SEC, I'm here. I created this LLC. I'm raising $1 million. I've got non-accredited or whatever. I'm relying on 506B. It's just letting the SEC know that you're out there. That's actually the information that they use to gather all the statistics. The reason I know that 92 or 92.5% of all exemptions are between 506B and 506C is because of that Form D that everybody collects. So the Form D is important, but we're not asking for permission, okay? And so the only other exemption really that has that preemption, which is why it's starting to become more and more popular, is this Reg A, or actually specifically Reg A Plus, because Reg A has 2 parts of it, and one of them isn't preempted. This is one of the reasons you never heard of Reg A before it got updated about 5 years ago, because it did not preempt state law. So having to do a Reg A meant you had to go hire an attorney in all the 5 or 6 or 10 or 12 different states, and nobody wanted to do it. And plus the limits were like $5. So now that they've updated the rule and now it preempts state law, then now everybody's excited and people are actually using it. It's got it. And we'll talk briefly about Reg A, but that's one of the reasons Reg A has become more and more prominent over the last few years, because it preempts state law. So because 506B and 506C are the most popular, and certainly if you're just beginning, you're probably going to rely on one of these two. I wanted to go through kind of quickly about sort of the bullet points of these. I'll hit some highlights, and if you guys have some specific questions on those, of course, we'll answer them after this little chat. So 506B, between B and C, B is beyond the most popular, right? So 92% of all deals between B and C are actually 506Bs, and the other only 8% are 506Cs, which is actually a little bit surprising at some point. You would think that with 506C and the advertising, that would be a little bit more prominent. The statistics are a little skewed just because a lot of the big, JP Morgans, Merrill Lynch's of the world, BlackRock, they actually raise billions of dollars, and they do it under 506B because they use broker dealers. And so when you use a broker dealer, you can use their relationships. And so they qualify for the B. I would say that in our practice, it's closer to probably probably two-thirds of our deals are 506Bs and a third are 506Cs. But again, if you look at the Form Ds, 92% of them are 506B and the rest is 506C. So again, if you're a newbie, and I hope that's not a bad term, but if you're a new syndicator or you're thinking about syndicating, most likely you're going to start with the 506B as in boy. And the reason for that is, number one, you can raise an unlimited amount of money. So that's great. That's why BlackRock can raise, I used to say 2.6 billion, but now they're in the middle of a $50 billion raise. It's under, well, actually, I haven't checked the 506B. I know the $2.6 billion raise was a 506B. Again, only accredited, but 506B and their broker dealer fees were outrageous. But you can raise an unlimited amount of money, so that's not an issue. You can take a limited number of non-accredited investors. That's probably why it's such a popular exemption. You can take, when you're just starting out, you're probably just taking money from your friends and family and your Uncle Bob and Aunt Karen. And so inevitably, some of those friends and family are going to not have the net worth or income requirement, which I'll get to in a second. But 506B allows you to take up to 35 non-accredited investors. And an accredited investor is anybody who has $1 million in net worth, excluding their primary residence. And on the income side, it's anybody who has earned $200,000 the last 2 years with a reasonable expectation of earning that or more this year. And if you're combining your incomes with your spouse, that number goes up to 300,000. And so being able to accept up to 35 non-accredited investors is really the main reason I think that everybody starts off with the 506B, because you're starting off with friends and family and people that are already sort of in your network. And inevitably, some of those are going to be non-accredited. The big drawback of 506B is that you are not allowed to advertise or generally solicit. So you cannot post on social media. You can't go on a podcast. You can't, it's meant to be private. It's supposed to be people you already have relationships with. And in fact, generally speaking, you have to have what's called a pre-existing substantive relationship with your investors. And the fact that it's pre-existing means that once you've got your deal up and running, you can't go advertise, because if you advertise, you obviously didn't know them before your offering before the offering started. So having a pre-existing substantive relationship is the way that you show that you didn't advertise or generally solicit to the investor. That's kind of like your safe harbor rule. So unlimited raise, up to 35 non-accredited, no advertising, no general solicitation. There's a bad actor requirement, meaning if you've been convicted, you or your sponsorship team or anybody in your sponsor has been convicted of some bad act, and that's generally securities related. So if you've been slapped on the wrist, or had some cease and desist, or you've convicted, obviously, of securities violations, you would not be eligible. That's not true. If it happened prior to 2013, if it's prior to September 2013, then you have to just disclose it. If it happened after 2013, you're actually barred from raising capital if you are considered one of these bad actors. You can get a waiver from the SEC, but and actually I don't really know how hard that is, but certainly if you've been convicted of some securities violation and you've been barred from raising capital for a while, it's going to be difficult to get that exemption. But anyway, that's 506B. And of course, this Form D that we talked about, Form D comes from the Reg A Exemption. You've got to file that within 15 days of your first sale to your investors. And then you have to file a copy of that Form D in every single state where you have investors located. And that also has to happen within 15 days of the first sale in that particular state. It's only a one-time filing. They have their fees or whatever, but that's the one thing that the states kind of insist on. Now, just a quick point on that, a failure to file a Form D according to the SEC does not blow your exemption. So for whatever reason you didn't file it, you're still going to be okay in terms of being able to rely on 506B or 506C. I would not recommend not filing it because the states will get really pissy at you. They will allege that you've blown your exemption, even though that's not true. You're going to spend a lot of money, a lot of time sort of responding to them, and you're going to end up with a fine, and you're just going to end up paying a fine. And they could theoretically bar you from raising money in that particular state moving forward. So you want to file those Form Ds, but if for whatever reason you've blown it and you've forgotten to do it and you've gotten into issues, you're not going to blow your 506B exemption. So anyway, that's 506B. 506C is you just say it's a relatively new exemption, but it actually, it's been like 7 or 8 years now. It's from, I think, 2000. Well, I know it's from 2012, but it really didn't start becoming effective until 2013, which I guess is 9 years now. But prior to this, we didn't have 506C, right? We just had 506B, and the main differences, I mean, they're all basically identical except for 2 important things. One is it allows you to advertise. Right. So 506B prohibits advertising. 506C actually allows you to advertise, even though technically it's a private offering still. You're actually able to go to the public. You're able to go on social media, on a podcast, on a radio ad, however you want. You want to go to a trade show, you want to have a booth, whatever you want to do, generally solicit or advertise, knock yourself out under a 506C. This is a big change that happened as a result of the laws in 2012, which happened, by the way, right after the great financial crisis of 2008. Nobody was being able to raise capital, so they loosened up the rules a little bit, or actually a lot, where you can now go advertising. However, they put a very sort of strict limitation on that, which is, yes, you can advertise, but you must limit your investors to accredited investors only. And furthermore, you must take what's called reasonable steps to verify that they are in fact accredited. You can't just take their word for it, as you can in 506B, which I guess I left that out. In a 506B, we just give them a questionnaire, they check the box, they represent to you that they're accredited or non-accredited, and you can reasonably rely on that representation as long as you know for a fact that they're not lying. I mean, if it's a homeless guy that comes to you and says they're accredited, is that really reasonable? But generally speaking, you can rely on the questionnaire. You cannot rely on a questionnaire under 506C. You must take reasonable steps to verify, which I would highly recommend. In fact, I would insist, if you're a client of ours, that you use one of these third-party verification companies that will actually do that compliance for you. They will go sift through whatever records they need to look through to confirm that they're accredited, either because of the income and net worth. And it's so inexpensive, think $50, $60, $70 per investor. There's really no reason why you shouldn't be offloading that compliance requirement from your shoulders to some third party, because once they do the verification, they send you a nice little letter that says, hey, we've verified the investors, you're good. And now you're in the clear. You don't have to worry about whether, they're lying to you, or you didn't take reasonable steps, because accepting that letter from a verification company is going to be considered reasonable steps for you. So those are really the 2 pivot points. 506C, you can still raise an unlimited amount of money. 506C, you still have the bad actor issues, and 506C, you still have the Reg D, the Form D that you've got to file within 15 days. Everything else is the same. It's just the pivot point. So whenever I'm talking to a client or a prospective client, and they're like, hey, which exemption shall I go with? I always say, look, do you want to advertise? Do you not want to advertise? That's pivot point number 1. And number 2, do you want to take accredited, or do you want to take accredited only? Because if you want to take non-accredited, you don't have a choice. You got to do a 506B. If you want to advertise, you don't have a choice. You got to do a 506C, at least between those 2. So anyway, those are kind of the 2 most popular ones. And like I said before, Reg A plus, we call it Reg A plus because there's 2 tiers to it. And this is sort of the second tier. That's the one we're going to talk about, has become more and more prevalent over the years, because it has this preemption feature that didn't exist prior to these updates happened, I think now 5 or 6 years ago. I'll briefly touch on Reg A, because if you're a newbie, you're probably not going to use Reg A, but I want you to know it's out there in case you're maybe a newbie that, I don't know. I mean, we've got clients who are newbies, but they've got a huge, YouTube audience and can reach a lot of people. So a Reg A may make sense. A Reg A allows you basically to have your cake and eat it too, to an extent. It allows you to advertise your deal, and it also allows you to have non-accrediteds in your deal, right? So you can advertise and you can have non-accrediteds in your deal. You are limited to 10% of their income or net worth, whatever is highest. So you can't just take all of their money. So there's going to be some amount limitations, but you can take non-accredited. And so the next question I always get is, well, Mauricio, well, why are you telling me this now? This sounds like an amazing exemption. Why don't we all use it? And the reason is because this does require what we call sort of a mini registration with the SEC. So we do have to ask for permission from the SEC, and that's a process that takes time. So instead of a Reg D, we just prepare all the documents, which I may or may not talk about all the documents. If you guys want me to, I'm happy to. But we basically don't ask for permission, right? We just prepare our documentation. We just make sure that we're in compliance with the feds and whatever, to the extent we need to comply with the state. But we don't. Oh, I lost my train of thought. We don't. We don't ask for permission, right? We just do it. And then obviously if we ever get audited, we've got that in our files and we can show it to them. But with a Reg A, you actually file it with the SEC, and that generally takes about 6 to 9 months as a process. And so again, if you're in contract to buy a building and you've got to close in 60 days or 90 days or even 120 days, no matter how many extensions you get, you don't have that amount of time to go and ask for permission from the SEC and get it through that process. And as you can imagine, anything having to do with the government, that again, it takes time and it takes a lot of expense, because now instead of having to just prepare the documents, we actually have to negotiate and interact with government attorneys, where they're going to look at our draft documents. They're going to send it back to us and they say, you got to change this, you got to do that. We don't like this, give us more of this. And so we kind of go back and forth. And so that just increases the cost associated with doing a Reg A. It's probably about 5x, if not more, to do a Reg A than it is to do a Reg D or 506B or 506C. So Reg A's only make sense, in my opinion, is if you're doing a fund, right? Because when you're doing a fund, you don't have a deadline. You don't have the pressure of having to close within a certain amount of time. You can literally wait a year or two as you put your fund together. And if you want to take the time and expense to go register it with the SEC or get their approval, once it's approved and I can now, advertise that, I can take non-accredited. So it is something to keep in mind. You can raise not an unlimited amount. They just upped the limit to 75 million. But again, I don't know how many, especially if you're a newbie, you're going to be raising more than that. But obviously, if you want to raise more than $75 million, Reg A is not going to work. But something to consider if you're doing a fund. Again, funds are generally not what you start with. You're generally going to start with sort of a single property where you're having your friends and family invest, which is one of the reasons we generally see the 506Bs as the most common exemption. The other thing I wanted to talk about is I wanted to touch a little bit on the social media issue, because this is becoming, I don't know what the right word is, but it's becoming an issue. Again, if you're doing a 506C, you don't have to worry about it. Knock yourself out. You still have some restrictions, right? We always have the anti-fraud provision, so we don't want to go too crazy. I generally recommend, if you're doing a 506C and you're posting on social media or on a podcast or on your website, don't forget your website's also public, that you at least have a little disclaimer in there, say, hey, look, this is a 506C, it's for accrediteds only, so that you don't get into any hot water with either other people or regulators. And again, I wouldn't get too specific on any social media posts if I'm doing a 506C. I would say, maybe here's what we're doing, kind of more broader sense of what you're doing. Hey, I'm raising capital. Here's what, maybe a range of returns that we're looking for, and then, take them offline and give them sort of more detailed information. But generally speaking, a 506C, you're gonna have a lot more leeway than a 506B. With the 506B, my recommendation is generally stay off of social media, stay off podcasts, stay off of any of that stuff if you have an active deal, because it's just very subjective and very gray that if you have an active deal, yes, you can post about your kids and your cats and what have you, but I would stay away from posting about anything really real estate related if that's what you're raising for, because there's something called conditioning the market, right? And that's probably the most nebulous term that's out there these days. But an offer, which is what the SEC actually regulates, can include not only, if you're, obviously if you're talking about a specific deal or pitching a deal on social media, that's obviously going to be advertising. But even if you're not pitching specifically a deal, but you're just posting in general that gets people excited, potentially excited about your deal or a future deal that you may have, that's what we call conditioning the market. So it's possible for you not even to reference, your specific deal. For example, you could say, hey, we're call us if you're interested in our future deals. We're giving investors, generally we're getting investors 15 or 20% IRRs. You should definitely call us next time, or call us to find out how you can get something like that as well. You're not talking about a specific deal, but you're going to be considered conditioning the market, which I would argue that if I wanted to, if I'm an SEC regulator, I can pretty much make anything into conditioning the market, right? So it's a very, very gray area. So the way to use social media, in my opinion, I think there is a place for it, is to, number one, just use it while you're in between deals, not when you have an active deal. But even then, you don't want to be posting about, prior deals and what the returns were, or what you generally get from your investors. What I recommend is, there's two things you can always do on social media. One is you can always post about factual information about you and your company, which isn't super exciting about, bio stuff, but you can do updates on your projects. Look, if you're doing a value add project, you want to do it before and after pictures, or just kind of like, just sort of the progress of your company as a whole. I don't have a problem with that. I think that would fall under the, the general information about you and your company, as long as you're doing that on a regular basis, right? You don't want to be like, not posting anything or doing any advertising in that form, and then you have an active deal and suddenly you're posting all day long, and then once you close the deal, you're not posting anymore. So you want to be consistent. But if you're constantly putting out content or information about your company, you and your company, that's allowed. But the big one is value add, right? You can always add value to your audience, whether it's social media, podcasting, websites. Nothing wrong with having writing an article or a webinar about, why real estate is the greatest, asset class to build generational wealth, or why, Jacksonville, Florida is the hottest real estate market, or why we like mobile home parks, or why we like self-storage, or just kind of that kind of educational material. And if you can get a contact information or an email capture from that, you can then go ahead and start a relationship with those people. So that's one of the reasons people put together webinars, and a lot of reasons why you see a lot of syndicators doing a podcast, because it's a way for them to add value to their audience, get an audience going, and every so often they'll start collecting their email content by putting out reports, or maybe a podcast, or some exclusive thing. They'll get that information in there. So so adding value to me is the way to do it. But even when you get that email from that person, when you get that contact information, you still have to take that person that you don't know, right? Maybe you even met them at a conference, right? You go to a conference, you meet a bunch of people, you gather a bunch of business cards. Now what? Right now you've met this person, they're basically a stranger. You've got to have a pre-existing substantive relationship with them. So how do I take this person from a complete stranger and turn them into a person that I would have a substantive relationship so that I can offer them a deal? And the answer to that is these 8 steps. I don't know if you've heard of these. I talk about the 8 steps all the time, but there's 8 steps that's generally accepted. If you take most of these, this is sort of the blueprint to take them from a complete stranger to somebody you have a substantive relationship, so that you can then offer them a future deal. Because again, you've got to have a pre-existing relationship with these folks. So even if you establish a relationship with them today, if you've got an ongoing deal, they're not going to be eligible for your current deal. You've got to wait for the next one down the road. But that's why you want to put in the work now to get to know these folks. So I'm going to go through all 8 of them, because really the most important are the first 2, or the most, the one that takes the most time. But you want to start by sending them a questionnaire. There's a detailed questionnaire that I would send out that says not only what's your name and your net worth and favorite color, but, a little bit more detailed, what are your goals? Are you a growth investor? Are you conservative? Are you high risk? Are you cash flow? Are you, equity? Like, are you, what's your level of experience? Similar to those questionnaires that you get when you've ever opened up a margin account or an options account at a brokerage firm. They ask you all these questions, very similar to that. So you want to send them a questionnaire so you get some idea of what they're looking for, what experience they have. And then you want to get on a phone call with them, or a cup of coffee or something, or a Zoom or whatever, to then talk to them and find out, whether this person, your investments in general are suitable for this individual, and are they really sophisticated? And so what you're trying to find out in these interactions with your prospective investors, you're trying to find out whether these folks are sophisticated. Do they have the necessary, financial and business acumen to understand the risks and the benefits of your investments? That's what you're trying to do. And the SEC has been very, very clear that there's no magic timeline. There's no 3-touch rule. There's none of that. You've probably heard some of that stuff. They're looking for the quality of the interaction. They're looking for, that's what the quality of the interaction between you and them. You're asking them questions. They're asking you questions. Hey, what are you doing? What's your, what are your values, and what kind of investments do you make? You're trying to just get that relationship going, and you want to be documenting that. That's probably the most important thing of all of this, is you want to document that, because if something were to go wrong 5 years from now and somebody claims, hey, I don't know this person from Adam, you want to say, no, I had a pre-existing substantive relationship. Look at my files here. Here's the phone call. Here are the emails. Here's the, the notes from our call or the recording from our call. Here's all that information. So the 8 steps are critical to take somebody that you don't know, whether that's from a social media post or somehow you've interacted, or maybe it's an event, a seminar. There's a lot of these that I go to that I've met most of you guys at some of these events. You're collecting business cards. Don't be that person that goes to a conference, collects a bunch of business cards, and then blasts out an offering, which happens to me all the time, because I go to these conferences, I give out my business card, I collect business cards, then people forget that I'm there as an attorney and not necessarily an investor, and lo and behold, 2 weeks later, I get an email about their new 146-unit apartment deal in Florida. And I don't even know who this person is. So clearly you haven't gone to the 8 steps. They haven't gone through the process of getting to know me. They don't know anything about me. And that would be a violation of this advertising rule, a general solicitation rule, because you don't have a pre-existing substantive relationship. So anyway, I think I'm gonna stop it here. I want to get to questions, because I've been babbling for a good half hour, and I could probably babble for another 2 hours, but I'd much rather get to your specific questions. And so I'm going to go through those right now. And wow, I really appreciate you guys with subscribing to the YouTube channel. So if you're watching this later, if you can go to mauriciorauld.com. Well, actually, if you're watching this, you're on YouTube, so just hit the subscribe button. But I appreciate it. I posted the link earlier before we started, and I really appreciate Tracy and Luke and everyone who's Derek who's subscribed. All right, let's go for some questions. I'm going to answer newbie questions first, and if we've got time, I'm going to answer the more sophisticated questions. But let's go. Here we go. Number one, if the asset is held in a TIC, is there a number of participants that is exempt as a security? The structure itself doesn't matter. So if you want to structure something as a TIC, that's fine. There's sometimes reasons you would do it as a TIC, primarily 1031 issues, or if you have a small amount of people, a joint venture potentially could be a TIC. But again, it's still a security. So you're still going to be limited. If you're doing a 506B, you're going to be limited to 35 non-accredited investor, but I hope you're not going to have a TIC with 35 or 40 people. But again, the structure itself doesn't matter. So whether you're doing it under a TIC or an LLC, you're still going to be, you're going to have to follow the rules that I just mentioned earlier. So there is no number of participants other than the 35 non-accredited. Now, what you might be asking is there are, and I don't want to get into the 1031, but if you're structuring it as a 1031 for 1031 purposes, which we did an episode early on 1031s, then one of the IRS limitations that you've got to limit your TICs to 35, same thing. So, but again, I can't imagine you're going to have a TIC agreement with 35 people. I don't know why you would do that. But anyway, so no, the answer is there's no specific exemption for that. It's going to be, again, if you're raising money, right, for that TIC, and you're the one generating the returns, you're the sponsor, you're the GP, then it's going to be a security. One of the things I didn't point out, by the way, is this little GP thing. I wanted to make this comment. People use vernacular, which is sort of the GP LP, and that's fine. That's the vernacular everybody's using. But just understand that we typically are using limited liability companies, LLCs. That's how we typically hold the asset. And an LLC doesn't have GPs and LPs. They have managers and members. So when you hear the term LP, what really you're talking about is that there's the passive investors, and those are generally members of that LLC. And where it gets tricky is when you're talking about the GP is really the management company, right? So the LLC will have a manager, and that's also usually an LLC. That's the manager that houses all of the sponsors. And so that entity is the quote unquote GP with all those people, but the GP also has an ownership interest in the LLC, right? So they may have 20% or 30% of the deal. That's a sort of a separate thing. You've got the GP or the manager that simply manages, collects management fees. And then you have the ownership piece, which is the carried interest, what we talked about. So even though you're listening to GPLPs, back in the day, they used to all be limited partnerships, and which is why that's where it comes from. But today, I mean, unless you're doing an oil and gas deal, there's really almost no reason to do an LP structure, or I guess maybe if you have a bunch of Canadians, because they don't recognize anything other than LPs. But anyway, just wanted to make that quick point on GPs and LPs. Let's see here. Dan, I'm not sure. Miana, cost of Reg A versus Reg D. It's about a 5X. I mean, a Reg D typically is going to run you somewhere around that 15K, give or take, a little bit less, a little bit more, depending on what you need. A Reg A is going to run you 80 grand, if not more, because they depending on how it's billed. We've stopped doing Reg A's for a variety of different reasons, but a lot of times they'll charge you, your typical fees, and then they'll just do an hourly depending on how much back and forth you spend with the attorneys over at the SEC, because that's kind of an unknown. And so some attorneys will actually just bill you hourly. So they'll do a flat rate, and then on top of that, whatever hourly they spend back and forth with the attorneys. But, you might go through, especially if you've never done a Reg A before, you're going to go through multiple drafts. You're going to draft your PPM and all your docs. You're going to send them to the SEC. They're going to wait 30 days and they're going to review it. They're going to send back your comments. You second draft, send it back to the SEC. They look at it again. They give you some more, and you go back and forth. And like I said, the whole process usually takes about 6 months, plus the amount of time it takes to prepare the docs. And of course, it can take a little bit less, a little bit more. One of the ones I did was actually during the holidays, and so yeah, good luck with that. Are you limited, Miana? Are you limited to 35 non-accrediteds with a Reg A? No, in a Reg A, you do not have that 35 non-accredited limitation. You can, I don't want to say unlimited, but basically you can have, let's call it 500, because there's some other issues that pop up once you have more than 5. You actually have to go public if you have more than 500. But for our purposes, you can bring in as many non-accredited investors as you want, but there's the income or net worth requirement. So there's a limitation of how much they can invest. They can only invest up to 10% of their income or net worth, whichever is more. So if I'm making $60,000 a year, I'm only going to be able to put in $6,000. If my net worth is 450 grand, I can put in $45,000. So there's that limitation of 10%. But if I want to bring in 85 non-accredited investors in my Reg A, knock yourself out. Jose, if you're a guest on a podcast and planning for a 506B, what is the best way to mention shifting your strategy to syndications without advertising? I think talking about your story is fine. Again, factual information about you and your company. So if you're on a podcast and you want to talk about how you were slaving away at a W-2 corporate job and you found real estate, and these are all the reasons why you love real estate, leverage, hedge against inflation, taxes, all that stuff, and you started syndicating, and that was a life changer, and it led you to quit your W. That story is going to be just fine. What you don't want to be doing is talking about really anything specific. I would be talking about your past deals, or certainly if you have a current deal, I would be very, very careful if you have a current active deal. If you're on a podcast, what I would highly recommend is having something of value on that podcast, so that you can say, hey, if anybody's interested in reaching out to you, it's like, hey, look, I've got this great white paper, ebook, whatever you want to call it. That is, again, why real estate, or if you've got a particular asset class. Most people know a little bit more about multifamily, but if you're in a more unique, self-storage, like I said, mobile homes or RV parks or whatever, putting a nice little comprehensive report or something on why you love that asset class. And then just say, if you want a copy of it, send me an email, and then boom, now you've got your email, and you can start emailing them and reaching out to them and going through those 8 steps before offering them a future deal. What are the rest of the 8 steps if you have the time, please? This is not meant to be I've got an ebook called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And I have all 8 steps in there along with a questionnaire. So if you want to, I think if you can get it, I think the link is still good. If you go to jail@premierlawgroup.net, jail@premierlawgroup.net will give you an autoresponder to get that ebook. And again, knock yourself out. You're welcome to steal that questionnaire. It's pretty detailed. I couldn't find, everybody was sending me the questions. I couldn't find a good one, so I just put one in there. But essentially, let's see if I can go off the top of my head. So the questionnaire is definitely the first one. The phone call is number 2. You want to have emails back and forth. You want to encourage them to check out your website. You want them to pull a credit report. I'm going to say most people don't do this one, but that's one way for you to confirm their identity and their assets. And then when they tell you they're sophisticated and have, $1 million in net worth, that's one way you can find out. I wouldn't say most people do that one, but again, generally you just want to be, communicating with them offline, which is the emails. You want to be having a website, encourage them to peruse your website. These days you can track all that stuff, right? So if you're not using a tracking system, you should be able to have a report, say, look, this is how many times this person visited my website, these pages, all that stuff. are part of those 8 steps. But the hardest ones are really, or the one that takes the most time. I mean, emails are emails. Encouraging someone to peruse your website is a one-liner. The questionnaire and the actual, interaction, phone call, coffee, dinner, lunch, whatever you want to do, are the top 2. Next question: Can sophistication be a replacement for accredited? No. So those are 2 different things. Let me see if I can say this correctly. For better or for worse, all accredited investors are sophisticated under the eyes of the SEC, right or wrong. But not all sophisticated investors are accredited. So there's really theoretically 3 levels, right? Well, actually, there's a lot more. There's other qualified investors, but for our purposes, there's really 3 types of investors. One is you're accredited, right? One is you're not accredited, but you're sophisticated. So sophistication simply means, again, the definition says, you have a sophisticated investor is somebody that has sufficient business and financial, wherewithal to understand the risks and the merits of your investment. That's what a sophisticated investor is. And then you have the third category, which is you're not accredited, nor are you sophisticated, whatever you want to call them. So that's a non-sophisticated investor. Those people are not allowed in any of your deals, right? So they have to be at least sophisticated. And the way you determine whether somebody's sophisticated is through these conversations that you're having with this potential investor, which is why you want to have these conversations and document all that journey so that you can say, you know what, I spent a couple weeks or a few phone calls or whatever we've been doing, and I feel pretty comfortable this person does have the financial wherewithal and acumen to determine the risks and the merits of all our deals. We went through it. I've talked to them. I documented it. So we're good. So they become sophisticated. Plus, they make representations to us, through the questionnaires that they are sophisticated. They have some experience. So, but it's not a replacement. You're primarily accredited or not accredited, but if you're not accredited, you have to be sophisticated. Roger, can you take a 506C to a broker dealer? You can take anything you want to a broker dealer. That doesn't mean they're going to accept you. That's the challenge with broker dealers, right? And that's one of the gaps that we have in our industry is that, on the one hand, you can't pay somebody to raise capital for you. We didn't get to that, but that's something else, sort of a basic. You're not allowed to pay somebody to raise capital unless they're a broker dealer. The challenge is broker dealers, it's a lot of work for them and they spend a lot of time with their relationships. They don't want to work on $1 million deal or a $2 million. They want to do 50, 100, $500 million deals, right? And so it's not impossible. In fact, more and more clients I've seen are working with smaller broker dealers that are getting paid a commission or maybe a cut of the GP just solely for going out and raising money. But it doesn't matter if it's a 506B, 506C, Reg A. You can take any deal that will accept you into a broker dealer. Federico, can you post the 506B deal on a community like GOB Slack or a Slack chat? That's a similar question to, can I post my 506B on a private Facebook group or something? It all goes back to whether you have pre-existing relationships with those folks, right? So generally speaking, I would say a Facebook group or a Slack group for a Slack chat, you probably don't have a substantive relationship with all those people. If you do, great, then you're good, but you probably don't. And so the only way the way I've thought through this and explained it before is that if you want to have a Facebook group where a prerequisite for them to get into the group, or in your case, the prerequisite to get into your Slack chat is that you've gone through these 8 steps and you've established a substantive relationship with them. And so it's almost like you've gone through these 8 steps, you've decided that you have a substantive relationship, and now you invite them to the Slack channel or the chat or the Facebook group, then fine. At that point, if you've got to talk about a deal, they've been not vetted, but they've been approved, so to speak, right? However, that doesn't mean everybody else in the group can then pitch their deals because they don't have a pre-existing substantive relationship with everybody else. So again, the structure itself, it's similar to what I talked about earlier. The structure itself doesn't matter. At the end of the day is, do you have a pre-existing substantive relationship with your investors? Or is there another way that you can show that you didn't advertise or generally solicit that particular investor? Roger, what kind of fund would you suggest for a builder of spec houses? I'm going to skip that one, Roger, just because it's not really a newbie question, but most newbies aren't going to do funds. But if I've got time here, I may be running out of the questions here. So if I've got time, I'll go back and answer that, Roger, if that's okay. Alice, can you please post a link to the ebook? Let me do everyone here. I think it's just jail at premierlawgroup.net. That's an autoresponder, so you just get it. I actually do have, Ashley, I saw you on here too, Ashley. I bought the domain stayoutofjail.com, but I haven't done anything with it yet. So one day it'll be on there. But for now, it's just an autoresponder, or you can just reach out to the team and they'll get a copy for you. Oh, there you go, Ashley. Thanks. I see you there. Thank you, Ash. Do foreign investors need to be accredited? That's a good question. Yes. If you're, again, it's the exemption, it's not the investor. So if you're doing a 506B or a 506C, then the same rules apply to your international investors as they do to your local. So if you're going to rely on a 506C, for example, and then you have to take reasonable steps to verify, they have to be A, accredited, and you have to take reasonable steps to verify, the same is going to apply to that foreign investor. To be a little bit trickier on the income, there's conversions. What if they're right on the border there? What conversion rate do you use? What's the official rate? At what point do you use it? So you definitely want to have this verification company do that. So even with foreign investors, you're going to go through the same process. It's going to be a little bit harder to document that, right? Because they don't have W-2s, or they may not have W-2s. They may not have, might be easier, which again is another reason why just spend the $50 and get another company or a broker dealer that charges $50 to do it for you. Where you can kind of get around that, and this is definitely not newbie stuff, is that there's another exemption. So we talked about Reg D, right, which is the 506B, 506C. We talked about Reg A, specifically Reg A plus. There's another exemption called Reg S, as in Sam, and Reg S applies to international investors that are non-U.S. citizens, non-U.S. persons, live physically outside the United States. It is possible to structure a deal where you're relying on both the 506B and a Reg A, and a Reg S for those international investors. And as long as you're complying with those rules, again, the SEC doesn't really care about foreign investors, right? In fact, they don't even have any jurisdiction over them. So there are some considerations to think about. But if that's a concern, if you're trying to do a 506C, for example, and your foreign investors are non-accredited, then maybe we get them in through Reg S, through a different exemption. Because if they're coming in through the Reg 506B or 506C, the exact same rules apply. Tracy, can you send email to the investors through the email mentioned the offer? I'm sorry. Can you send email to the investors, though the email mentioned the offer is only for accredited investors? Does the email consider solicitation? It depends on the exemption. So if it's a 506C, I'm going to assume it's a 506C.
No, it's 506B.
So if it's a 506B, okay, so that's the good point that you just mentioned. Just because it's a 506B doesn't mean that you're going to have non-accredited. In fact, I think this is where Tracy's going. So a lot of times 506Bs are just accrediteds only, even though you have the option to bring in non-accredited, you're not obligated to, right? And a lot of people don't want to bring in non-accrediteds because, they're less sophisticated. They're more, generally speaking, and they're just a different breed, and there's a bit more risk involved because the disclosures are different. So a lot of people, do 506Bs and they only accept accredited investors. So the question was, can you send an email to the investors under a 506B? Under a 506B, it doesn't matter whether they're accredited or not accredited. You must have, generally speaking, you have to have a pre-existing substantive relationship with those people in the email. And so your CRM or whatever, and it could be an Excel spreadsheet, whatever you're using to keep track of your investors, you should have a system in place where only the people that you have, that you believe you have and can document that you have a pre-existing relationship with, or that you, maybe better said, that you have not previously advertised to obtain that email, those are the only people that should be in that 506B list. You should probably have a separate list, or that maybe is a sub part of your list. All the other people that you met at the conference last weekend, that you met 100, you got 100 business cards, those people should not be in that 506B list. So whatever system, I use a little bit of Infusionsoft. So you've got the tags, or if you're Salesforce, I think they got flags or whatever you need to do to say, hey, here's my 506B list, which is different from my overall list, because all these other people are maybe in my 506C list because I don't know them, but that's okay because I don't need to know them under a 506C. So once you put them through the ringer and put them through that process, then you can move them over to your 506B list, so that when you do email out under a 506B, those people have already sort of been let's call it, it's not really a pre-qualification, but let's call it they're already pre-qualified for your 506B. Does that make sense, Tracy?
Yes, thank you.
Thanks, Tracy. Appreciate you. Obviously be offer. Okay, cool. Well, I've got a few more minutes. I'm going to go back to this question about, I'm not sure I even have the answer, but let me go back to this question about the fund and you want to, oh, here it is. What kind of fund would you suggest for a builder of spec houses? Well, from an exemption standpoint, again, I would ask you, do you want to advertise? Do you not want to advertise? Do you want to take accredited? Do you not want to take accredited? Because that's going to be your pivot point, right? In terms of a fund, it would just literally be a blind, what we call a blind fund. Well, actually, that's not true. It depends on it really depends on whether you're identifying, if you already can show the specific product, whether they're plans or architectural plans or whatever, then it's just like any other asset. Like I'm raising $10 million to go build, buy this land, do these, the surveys and all, do those pre-entitlements. Here's the plans. We're going to build these specs and then we're going to sell them or do whatever you're doing. So just describe the business plan. And it's just what we call a regular fund. You could do the blind fund, which is telling people you don't really have specifics. You're just like, hey, I'm going to raise a bunch of money and I'm going to go look for land. I'm going to go build spec houses that are kind of in this range. That's what we call a blind fund, which is a little bit harder to raise because people don't know what you're buying. They're going to rely on you as to, your good judgment. And if you've got a track record, that's easy. But if you're, again, a first timer, most people aren't going to bet it's betting on the jockey versus the horse, right? So if you're a first time syndicator, usually you want to establish a track record of what types of deals you're doing. So you get to a point where after you've done 5 or 6 or 10 of these, then the investors just trust you and just give you their money and say, look, you go find whatever you're going to find. If you're just starting out, my recommendation would be to actually have the land identified, ideally under contract already. It's like, here's the land I bought. It cost me $1 million. Here are the architectural plans. Here's all my hard costs, soft costs. Here's all the specifics. Here's the renderings of the final product. And here's what we're going to do to them. I think you're going to either sell them or rent them or whatever your specific business plan is. Then an investor can look at that and say, yeah, that's great. Or no, I don't think they can challenge your assumptions. They may not like the market. But so if you're just starting out, I would suggest the more specific you can get and the more, again, just like any other syndicator, get the land under contract even. So you can say, I've already bought, I've got the land under contract. This is what it's going to cost me. These are my soft costs. These are my hard costs. This is what we're building. And this is how we're going to exit. And this is how much profit, here's my pro forma. Okay. Thanks, Roger. Cameron, why do a 506B, but only accept accredited investors? A great example of this is Ken McElroy, who's one of probably the top syndicators around. He does 506B deals and only it takes accredited investors only. And the main reason is there's some pushback in terms of the verification process. So some investors are just not used to and don't want to be providing their financials to anyone, right? And so that verification process typically, just kind of throws some people off. And again, for some people, it's a big deal. I mean, if people have been investing with you for years and now you're suddenly asking for, a copy of your tax returns, some people don't like that. And if they've got options, if they can invest in 10 deals and 9 of them don't require me to give you financials and 1 does, I may be more inclined to do, one of the other 9s that not asking me for that. So that's usually the pushback or the arguments I hear about doing an accredited investment. I think, especially if you have a platform, if you've got a YouTube channel or you've got a podcast or something, I mean, I think 506C is the way to go because you can then, promote it from there. Irish Kevin, I see a hand up.
Yes, sir. Thank you, sir.
Good to see you.
Yeah, same here. Thanks for the invite and the platform for these questions and answers.
Yeah, of course. Love it.
Yeah, it's awesome. I had a question. If a sponsor has an active 506B deal, can an investor refer another non-accredited investor to the sponsor?
Yeah, so that comes up a lot actually. So yes, so the SEC, if you go to their website, I don't know if it's a website, the SEC comes out with these they're called CDNIs, like compliance, some Q&A thing. And there's a specific, I don't remember off the top of my head what the number is, but there's a specific Q&A in there that says having a pre-existing substantive relationship is one of the ways, but not the only way that you can prove that you did not advertise. So the rule says you're not allowed to advertise or generally solicit. The rule actually doesn't say anything about having a pre-existing substantive relationship. One of the ways, and when I say one of the ways, the 99 of the time or 95% of the time you show that you did not generally solicit or advertise this person is by having a substantive relationship with them. But in your example, if somebody just refers me, if I'm like, hey, I'm an investor in this deal and I love it, Irish Kevin's got a great deal, I love it, I want to bring my best bud over here and have him invite him to the webinar because he's looking to invest, and I make an introduction, you have not generally solicited or advertised to that individual. So I believe that you're going to be in the clear on that. You still want to have that conversation with them. You still have to make sure that this investment is suitable for them, right? You still have to make sure that they're sophisticated. So you still want to go through this process of getting to know them, but I'm not going to be relying on having a pre-existing relationship. I'm going to be relying on the fact that this person referred that person to me. I did not generally solicit or advertise. And in fact, you want to have that documented, right? You want to have an email. It's the easiest way. Just have an email that you can prove that person was referred to you as opposed to you reaching out to them. Because if you don't have an email of that referral, you're going to be in trouble. So just make sure that Johnny says, hey, Kevin, wanted to introduce you to Mark. He's a good friend of mine. He's looking to invest. I told him about your deal. He seems interested. You know, I'll let the two of you connect, something like that. And then that way you can say, hey, I did not generally solicit or advertise this person at all. So I'm good with that.
Right. And then if you're going from a 506B to a 506C,
yeah,
what kind of language has to be in the PPM? Does it have to be, is it like a lengthy type thing, or is it just a 1 or 2 sentence type?
That's I think that was my first episode, actually. Episode 1 was this pivot. So for those of you who aren't familiar, since there's a lot of new folks, you can now, as of about a year and a half ago, you can start a deal under a 506B and then pivot to a 506C. In fact, I just did a flip chart Friday on the YouTube channel about this, but 506B, then flip to a 506C. And there's a bunch of things you want to be doing. The way we do it is actually, we actually structure it in a unique way. So the PPM is going to be structured differently than a typical syndication. For example, we like to create separate classes of membership units, one for the 506B, one for the 506C, so that when you're out there advertise, once you've done with your 506B and you pivot and you start doing it under a 506C, it's very clear that you're selling, you know, class B shares as opposed to class A shares. You're just trying to really best practice to be very, very conscious and clear that when you're doing a 506B, you're obviously not advertising, you're not taking more than 35 non-accredited. And then once you flip, man, you better comply with 506C. No more non-accredited, you know, you've got to verify everybody else coming in. And obviously during the 506B, you don't want to be advertising. So I would encourage you to go visit episode 1, because I do almost a 2-hour deep dive into that, because we do structure it a little bit differently.
So you don't like have to put a date on it. It can just be like an open.
No, in terms of when the pivot happens.
Yeah.
No, there's no date on that. I mean, obviously you've got to close. So you want to probably get that 506B done, you know, all your non-accrediteds in there as quickly as possible, you know, and maybe you give them a deadline, say, hey, look, if you're non-accredited, you better get in the next week or two, because I'm going to shut it down, you know, in a month or 3 weeks. And so get in now. But once you pivot, the only thing again, not in the rule anywhere, but we think it's best practice is to have a written consent that's, you know, ideally even notarized so that nobody can argue that you know, the date that you signed it, or maybe you DocuSign it, whatever, but that you just say, hey, today, whatever today is, today on Tuesday, we are terminating, we're stopping our 506B. We're no longer taking non-accredits. We're no longer doing any of that stuff. There's no lingering documents, no lingering money. Today, we do a clean cut, and then starting tomorrow, or maybe starting in the next minute, we're going to continue doing this raise under a 506C, and we're going to comply fully with 506C, only accredited, taking reasonable steps to verify, all that stuff. It's got to be a nice, clean cut. My fear is some people are, and obviously we want to disclose it, so that's why the PPMs are different as well. You're going to have an updated PPM, you're going to have an updated business plan on the 506C, because it's slightly different. So there's a lot that goes into that. But there's no requirement that you have to tell them a date. And in fact, we've had clients that have structured it so they could pivot and then did not pivot because they just raised all the money. They did a 506B with the intent of, hey, if I can't close or I need to do a 506C, I'll go there. And they ended up raising all the money under 506B. So we never actually pivoted. Okay,
cool. And the last thing, I've been hearing like a rumor about how the SEC is talking about changing the net worth for an accredited investor.
Yeah, I don't have an update. I keep checking. I haven't checked in a week or so, but I'm sure I'll find out. So yeah, we haven't, you know, it was supposed to be in April or May of this year that they were going to have their meeting, but we're a ways still. We don't even have a proposed rule. I mean, they're going to come out with a request for comments, a proposed rule. We're probably at least another even if they came out with something tomorrow, it would be another probably nine months before anything happened. But for those of you who don't know, where they're talking about, rumor has it they're going to be increasing the net worth requirement for accredited investors from $1 million to something. There was rumors of 10 million. I think it's going to be closer to 3, so that it's adjusted for inflation from when the rule came out in 1982. But I haven't seen anything yet. And trust me, I'll probably do an emergency live as soon as I see that press release from the SEC. I'm sure I'll jump on here and we'll do a impromptu live to cover it.
Yeah, and then like, how would that affect 506B non-accredited people? It sounds crazy. Like,
yeah, I mean, if they're already done, obviously, if you've already done a 506B and they've come in, it's not going to be an issue. But yeah, for moving forward, I mean, your next deal, if you're a 506B person and you have a new deal in 2 months, and now there's an updated definition, then there's going to be a lot less accredited investors out there. So
yeah, it's just like,
yeah,
they put a higher limit on accredited, but a 506B person, like non-accredited, is still going to qualify under the same definition.
Yeah. Well, yeah, I think the harder part is going to be the accredited. So if you're doing a 506C now, you're going to have less people to go. Most people that were accredited are going to be non-accredited, but there's going to be another path, right? You're going to have that path of being able to go take an exam and take a test. That's the thing, right? So on the one hand, you're not going to automatically qualify for an accredited. Let's say they bump it up to 3 million. And so you have a $2 million net worth. So you used to be accredited. Now you're not. Then you just have to go take a test. I mean, that's what they're looking for. It's taking some course and then take an exam and get certified. And now you're an accredited investor. But it's not going to be based on how much money you make. It's going to be based on studying and passing an exam like any Series 65 or any other securities license. So anyway, I got to head out of here. Appreciate you guys very much. If you are not part of the Facebook group, I'm always in there. If you've got another questions, if we didn't get to any of your questions today, pop them in the Facebook group. It's the Real Estate Syndicator Community. It's Mauricio. I'll put that in there too. mauriciorauld.com FB group. I'd love for you guys to join us there. We just crossed 2,000. It's pretty active. So I'm always there. So if you've got a question, just drop it in there. And I will see you next week, but I'll put this in the chat right now.